Hello, welcome to Potentially Criminal. My name's Sean Martin. I'm an attorney out of Cleveland, Ohio, and I focus on criminal defense matters. Today we're going to talk about an interesting question that was repeatedly asked by many of you guys during my streams for the Theodore Edgecomb trial. And that focused on the fact that Theodore's attorneys were not very good. They did a lot of things wrong, and it just seemed like they weren't up to the task. So a lot of people were asking, does that count as ineffective assistance of counsel? Sadly, the answer is no. And why do we know why the answer is no? Because there's an actual test for this. And that test was set forth by the Supreme Court in the case of Strickland v. Washington. In that case, David Washington had pled guilty to multiple murder offenses where he faced the death penalty. During the death penalty phase, his attorney failed to introduce many medical people and psychiatric personnel and other people in his life who David believed would be able to testify and show the judge he deserved life without parole instead of the death penalty. Those people were never brought forward by his attorney, and the judge eventually sentenced David to death. David appealed his way up, and the argument was that had those people been introduced, David would not be being executed. So the Supreme Court looked at this case, and they came up with a test. Now, the first part to this test is pretty simple. There has to be a deficient action by the attorney, and that has to cause prejudice. So what's deficient? Well, them not doing their job, and that could be any number of things. So if, for example, your attorney falls asleep, that's deficient. If your attorney is drunk, that's deficient. If your attorney has failed to bring in witnesses or bring in evidence that would be exculpatory and potentially help you, that's deficient. If your attorney fails to file certain things by a certain deadline, that would be deficient. If your attorney forgets to file your appeal even after you tell them you want an appeal, that can be deficient. But that's not the sole issue. The bigger part is what's here. The defendant must show that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. Now, what does that mean? That had they not messed up, had the attorney done his job, the result of the proceeding would have been different. A reasonable probability that it would have been different. Does that mean it's certain? No, you don't have to prove you would win. But the next sentence tells you what a reasonable probability is. Reasonable probability is a probability sufficient to undermine confidence in the outcome. Now, if your attorney fell asleep throughout your whole trial, well, I think there would be probability sufficient to undermine the fact that you were convicted. If the person in charge was asleep at the wheel the whole time, there's a chance that it could have been changed. Or if your attorney failed to introduce exculpatory evidence, evidence which could show that you are not guilty, well, that could have a probability to affect the trial. The same with failing to call witnesses. But it's not only just the outcome of that, but it's any outcome. Had your attorney filed your appeal timely, you would have been able to appeal. But since they didn't, you had no chance at all. So you have to look at what it is, and then did that cause prejudice, and then would that prejudice actually change things? In David Washington's case, the court pointed out that had those people David wanted to testify, in fact testified, they would have provided really, really bad evidence for David and would have that much more likely guaranteed he was sentenced to death. In addition to that, his attorney had spent time making sure that evidence was precluded from court. Now, in David's case, yeah, clearly it doesn't matter, but in other cases, could that matter? Sure. If you could show that that evidence would have gotten him a life without parole sentence, or likely a life without parole sentence, or possibly a life without parole sentence, that would be where it would be ineffective. Now, going back to Theodore Edgecomb, are his attorneys ineffective? Right now, no. They suck. They're not doing their job well. They're very incompetent, and this could be malpractice, but is it ineffective assistance? No, not in a million years. Theodore can argue that till the cows come home, and it won't change. And I don't see the standard getting lax enough to encompass his issues in my lifetime. So that's it for today, guys. Like I said, if you were hoping there was a chance for Theodore to appeal on ineffective assistance, It's not going to happen. Never will happen. He can try, but nope, not going to happen at all. So if you like what you see here, please like, share, subscribe, comment or questions below. And remember, until next time, just because you did it doesn't mean you're guilty.